For the first time in over a century, the US Supreme Court will reconsider one of the most fundamental principles in American law, birthright citizenship. The court has agreed to hear Trump v. Barbara, a challenge to President Trump's executive order seeking to deny US citizenship to certain children born on American soil. Hi, I'm Muhammad Amir. I'm an immigration attorney and the founder of Amir Law Firm. Today, we are breaking down how this case could reshape the interpretation of the 14th Amendment's Citizenship Clause and redefine who is considered a U.S. citizen at birth. Before I start, let me remind you that this channel is dedicated to provide you with immigration news, updates, and information. Make sure to subscribe to our channel. Also hit the bell icon so you can be notified as soon as a new video is posted. Background of this case. On his first day back in the office, President Trump signed an executive order declaring that children born in the United States would only be recognized as U.S. citizens if at least one parent is either a U.S. citizen or a lawful permanent resident. The order excluded children born to parents without legal immigration status or those on a temporary visas, such as students or workers. Multiple lawsuits were filed immediately, including Barbara v. Trump, a nationwide class action brought by several civil rights organizations, arguing that the order violated the Constitution and alongside the Supreme Court precedents. What this executive order does. The executive order directs federal agencies to deny citizenship documentation, like passport or a social security number, to babies born in the United States if their parents don't have citizenship or permanent residency. Birth certificates which are issued by state would still be given, but they would no longer automatically prove U.S. citizenship. The administration defends the policy as a way to curb illegal immigration and so-called birth tourism. But opponents argue it targets children and undermines constitutional guarantees. Let me give you some historical context for better understanding. The 14th Amendment was drafted in 1866 to repudiate the infamous Dred Scott decision, which denied citizenship to Black Americans. Lawmakers at the time made clear that the Citizenship Clause was meant to include children of all parentage born within the United States. The Supreme Court reaffirmed this understanding in Wong arc, ensuring birthright citizenship regardless of race or ancestry. The new order, opponents argue, tries to undo the post-Civil War guarantee, the legal foundation of this principle. At the heart of the dispute is the Citizenship Clause of the 14th Amendment, which reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. For more than 125 years, courts have read this language broadly. In the United States versus Wong arc, the Supreme Court held that anyone born on U.S. soil, except for children of diplomats or enemy occupiers, is a citizen, regardless of the parents' immigration status. That precedent remains the cornerstone of birthright citizenship today. The government argues that the phrase subject to the jurisdiction thereof limits who qualifies for the citizenship. Government claims the amendment was meant to apply only to freed slaves and their children, not to children of foreign nationals who are in the country unlawfully or temporarily. They say the text requires more than mere birth on U.S. soil. That true jurisdiction involves full allegiance to the United States. However, the challengers, including the ACLU and State Attorney's Journal, argue the order directly contradicts the plain language of the Constitution and Supreme Court precedents. They emphasize that Congress, not the President, defines citizenship by statute, and that executive order cannot override constitutional guarantee. In their views, the order is not only unconstitutional but would create chaos, bureaucratic confusion, and a class of stateless children. Lower federal courts quickly blocked the order, finding it unconstitutional and inconsistent with both the 14th Amendment and existing federal statutes. However, the Supreme Court has now agreed to hear the administration's appeal in Trump v. Barbara. Our arguments are expected in April, with a decision likely by the end of June. The court will decide not only the order's constitutionality, but possibly the scope of presidential authority in defining citizenship. Now, what is in reality is at stake? If upheld, the executive order could deny citizenship to hundreds of thousands of babies born each year in the United States to non-citizen parents, many of whom could become stateless. It could also force states, hospitals, and federal agencies to overhaul how birth and citizenship are documented. Beyond that, it could rewrite a defining element of the American identity. The citizenship is a right by birth, not a privilege by lineage. The question before the Supreme Court is simple yet profound. Does the Constitution guarantee citizenship to everyone born on the US soil, or can that promise be limited by executive order? Whatever the outcome, this case will become one of the most consequential constitutional rulings in modern immigration law. Stay tuned as the court revisits a principle that has defined America since 1868. Thank you for watching, and I will see you in my next video.